Welcome to today's program titled Radical Change at OSHA, What to Expect in 2025 and Beyond. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Adam Young. Adam, please go ahead.
Yes, good afternoon, everyone, and Happy New Year. It's great to have you all join us for this webinar. My name is Adam Young, and I'm a partner with the Labor and Employment Practice at Seyfarth Chicago office and a member of our Workplace Safety and Environmental Group. I'm here with Melissa Ortega, who's also a fantastic attorney in our Chicago Workplace Safety Group. We're here to talk today about what to expect from OSHA during the second Trump administration. If you have any questions at any time, please put them in the chat or send us an email. We are here to answer your questions and what is interesting to you all. And we'll do our best to address them during the presentation if we can. If not, we'll follow up with you later. Of course, because of this topic, we're going to be offering predictions for the future, which we'll be explaining potential big changes that we see taking place now or that we think will take place during the Trump administration. We're going to be basing that on and informed by our experience with the agency, our experience with the first administration, and what we've seen during the Biden administration and what we're hearing from the actors, from President-elect Trump, from members of his team, and what we can expect from them. We hear a lot of talk about big changes based on new administrations, every 4 years or every 8 years, talking about eliminating or combining agencies. This president-elect tends to make particularly attention-grabbing statements. In effect, we tend to see a lot of continuity with agencies and changes kind of eating around the corners. But here we do think there is the potential for some pretty big changes based on the statements that are being made. So we'll discuss those in detail. I'm going to turn things over to Melissa to talk about our agenda for the day.
Thank you, Adam. And thank you all for joining us today. And again, Happy New Year. Like Adam mentioned, my name is Melissa Ortega. I'm an associate in Seyfarth Shaw's Workplace Safety and Environmental Practice Group. If we can answer any questions or assist you in any way, please feel free to reach out to either Adam or myself. Our contact info will be shared with you at the end, along with the CLE code for those who want CLE credit. Today we're going to be discussing what we can expect in the OSHA world under President Trump's second term. We'll discuss the political landscape, OSHA enforcement, possible legal implications, and the dynamics with state plant states. We'll also discuss why OSHA citations matter, and at the end, we'll review some OSHA inspection management good practices so that we can all prepare for the incoming administration. And with that, I'll turn it over to Adam. He's going to discuss OSHA during the first Trump administration. Next slide, please, Donna. Thank you.
Thank you. The first Trump administration, OSHA was kind of like a captainless ship. There was no confirmed OSHA leadership. They had proposed a nominee who was a head of safety at FedEx. And that individual, the Republican-led Senate, never voted on that nomination. There was only an acting head of enforcement. There was no head of enforcement. So we saw a lot of, around the country, the 27 states where federal OSHA enforces OSHA regulations against private employers. We saw a lot of different silos of different outcomes. And the same type of citation we would get in Wisconsin versus Texas versus Massachusetts, we might get a different outcome in each one. So we saw, a lot of long-term career people kind of operating the best way they saw fit, and not a lot of top-down leadership. And that was in the context of flat budgets, right? At least the first 2 years, they didn't increase the OSHA budget. And their healthcare costs, their pay costs were going up. So we saw a relatively declining number of compliance officers for the size of the economy, declining number of inspections. But they didn't put a halt on all new programs. So there were new national emphasis programs that came out during the Trump administration, many of which are still in effect now, about trenching and excavation. They also didn't stop new regulations. There was a silica regulation that came out in 2020, for example, and they're working on several others during that time. So there was a lot of continuity with what we had seen during the Obama administration, with some limited change. Obviously, the agency had to greatly refocus in 2020 when they started getting 10 times as many complaints, and they were all about COVID-19. So they had to focus towards that hazard, more of a focus towards healthcare, and that was based more on events and probably less on specific decisions that were made. That the economy changed and the conditions changed and they had to refocus towards that. As I said, there was some employer-friendly policy change that occurred during the Trump administration, and we saw it in a few areas. One was an openness to voluntary protection programs, and those are voluntary programs with OSHA, where an employer comes in and provides information and gets certified, for example, as VPP Star. Not very popular with the Obama administration, more popular and more open with the Trump administration. Wellness programs, there was more openness to those. And then they put out a memo confirming the lawfulness of post-accident drug testing, which had been drawn into question before. So we did see some pro-employer trends, and I think we're going to see some of that in the second administration. But I'll turn things back to Melissa to talk about what we saw in Biden and the change in the law more generally.
Next slide, please, Donna. In contrast, under Biden, OSHA was led by Doug Parker. He was the former head of California OSHA, also known as Cal OSHA. Under Doug Parker's leadership, we saw an enforcement focus on what had been priorities in California, and those included heat illness, vulnerable worker populations, and workplace violence. For those with establishments or sites in California, that in this past July, there were some requirements surrounding workplace violence. Under Biden and Doug Parker, federal OSHA established a national emphasis program, which targeted enforcement of heat hazards under the general duty clause. OSHA later developed a heat illness rule that was applicable, or is going to be applicable, to the general industry and construction. And that was in April of 2024. OSHA is currently considering stakeholders' comments, and it remains to be seen how long OSHA under Trump will consider the comments and or whether it will even publish the final rule at all. Under Biden, we also saw a focus on construction with the National Emphasis Program to eliminate injuries and fatalities associated with falls. And we also saw a focus on warehouses and retail back rooms with a national emphasis program on warehousing and distribution center operations. I think both Adam and I saw a significant amount of program inspections under these two programs this past year. Under Biden, we also saw union-friendly rules, and that included OSHA's third-party walk-around rule, which broadened the grounds for when OSHA compliance officers can use their judgment to determine when a third-party representative, so like a union rep, can join a walk-around inspection. Donna, next slide, please. Under Biden, we also saw an uptick in press releases announcing injuries and citations of employers across the country. We also saw an uptick in severe violator enforcement program, which allowed OSHA to concentrate its resources on inspecting employers that they believed had demonstrated indifference to the act by committing willful, repeated, or failure to abate violations. So employers who were or are added to the programs list, they're on there for at least 3 years, and they are added to a log that is public. So anybody can view this log. OSHA also focused on repeats and willfuls and used employer knowledge of a past inspection to justify a willful classification of a present citation. We also saw an uptick in the use of the general duty clause and enhanced referrals to the Department of Justice for criminal prosecution in those fatality cases. Lastly, under Biden, we saw targeted enforcement of record-keeping violations and an increased request for employer root cause analysis and insurance audits. A good practice for root cause analysis are to get an attorney involved and do those under the attorney-client privilege. Donna, next slide, please. This past year, there was a shift in the regulatory landscape, and this is something that Trump did not have during his first term, so he will have the privilege of that in his second term. The shift is due in large part to the Supreme Court's decision in the case styled Loper Bright Enterprises. There, the court overturned the long-standing Chevron deference, and it held that courts, not agencies, so not OSHA, are best suited to interpret ambiguous statutory provisions, even in areas of a particular agency's expertise. In doing so, the court reined in agencies like OSHA from effectuating their enforcement agenda based on the agency's own interpretations of its regulations. And this wasn't the first time that the court had chipped away at OSHA's regulatory power. In 2022, in a case filed National Federation of Independent Business, the court granted a stay of the COVID Emergency Temporary Standard, also known as the ETS. And this was in response to the pandemic. The court found that OSHA exceeded its authority when it implemented the ETS. Under Trump, we can also expect changes in part due to the creation of the Department of Government Efficiency, which is aimed at wasteful spending across federal agencies, and that would obviously include OSHA. It remains to be seen what Trump, Musk, and Ramaswamy will find wasteful at OSHA. Lastly, while Trump has distanced himself from Project 2025, a lot of his Republican colleagues have endorsed the playbook, and a lot of Trump's own published agenda overlap with Project 2025. And Project 2025 generally aims, in part, to limit new regulations and reduce the footprint of governmental agencies. Next, Adam will talk about projections for the agency under Trump's second term. And with that, next slide, please, Donna.
Yeah, thank you. So obviously, we're going to anticipate new leadership at both the Department of Labor and then the Undersecretary of Labor, who'd be over OSHA with the change of administration. Those are political appointees. They have put forward Ms. Former Congressman Lori Chavez DeRemer as the new Secretary of Labor, who is about as pro-labor or pro-employee side as any Republican out there. And we're hearing an openness towards the agency with regard to her and her orientation, though we would anticipate, if push comes to shove, she's going to follow the guidance she gets from the administration. But that suggests maybe more openness to some of the union-friendly agendas that than we would have anticipated. Generally speaking, we're going to anticipate some more employer-friendly changes from OSHA, and I'll talk about those in some more detail. First, I've gotten a lot of questions about some statements that were made about potentially eliminating the Department of Labor or merging it with the Department of Education. We think those are being put out there apparently by some people associated with the Trump administration or the incoming Trump administration. Probably unlikely. They've been talking about eliminating the Department of Education since a year after it was created. I think that was in 1979. So the idea that the Department of Labor is going to be eliminated, an agency that employs, or OSHA specifically, employs people all over the United States. So there'd be a lot of, congressional districts that would be impacted by loss of federal jobs. It seems politically, even regardless of what the orientation was, an unlikely outcome. Flat or reduced budgets, I think, is something that we could anticipate. That's what we saw initially in the Trump administration the first time. What does that mean? It means fewer compliance officers and fewer inspections. And then a focus away from one thing they think they should be doing to another, right? So instead of programmed inspections, which would be going out where there's not an accident, there's not an injury report, but you just operate a facility that's on a list that an algorithm can pick for of anyone who operates warehouses. You could be going out on a program based on the fact that those hazards exist. We're going to see less of those program inspections and more targeted inspections. Targeted inspections relating to reported injuries, serious injuries, fatalities, and complaints. That's one change we would expect. And then from a philosophical perspective, we have heard Doug Parker speak many times. We attend the ABA OSHA conference every year. Every speaker during the Biden administration has talked about vulnerable populations, as Melissa addressed. And I think a lot of the intent of those orientations were to change enforcement towards certain demographic groups that were particularly affected by safety and health issues. And that would be very contrary to the more anti-DEI orientation that we're hearing from the Trump administration and its allies, that they wouldn't see those as the priorities as to where to focus attention and enforcement. There is more of an openness. I think unions typically don't like the voluntary programs where OSHA works cooperatively with employers because they feel may be usurping their role over safety. We think there's a great likelihood for enhanced consultation, for more cooperative programs, more openness to employers making work sites VPP or whole regions VPP in the construction industry. Where will we expect other cutbacks? Emphasis programs. So that's what generates those program inspections on certain things like warehousing and logistics would be the newer one that Melissa was talking about. We see less of those coming out, and probably a reduced emphasis on whistleblower claims and anti-retaliation claims as well. If we go on to the next slide, please. Yeah, so we also would anticipate, as I said, focusing on injury reports and doing inspections of those, but also on egregious and willful cases. That would be an idea to kind of focus away from going after unionized workplaces, which have been a big focus of the Biden administration, and towards employers who have histories of OSHA citations going forward. Limiting penalties for first-time offenders is something that's addressed in Project 2025, one of the few substantive OSHA recommendations that it makes, and certain exemptions for small businesses is discussed as well. There's already penalty reductions based on size, the size of the company. We would anticipate that they would consider adding to their field operations manual, an additional maybe reduction based on the fact that it's the first time you've received a citation in the past. This is the first time you've received an OSHA citation. Exemptions for small businesses. I think it's unlikely that OSHA would exempt small businesses who had a fatality from an inspection or enforcement through a citation because of potential blowback of doing that. But there could be some, additional size reductions that might make more sense. As Melissa talked about, there's some ongoing rulemakings. There's a heat illness rule that's still in the process now. They haven't finalized the rule yet. I believe the notice of comment period is still ongoing. We think it's likely that could be abandoned by the Trump administration, the federal heat illness rule. There's been a lot of political opposition to a heat illness rule, particularly from Republican governors in the southern part of the United States. And there's been laws have been passed to prohibit municipalities from issuing, water break rules or other types of things to protect individuals from heat illness. So we think it's unlikely they're going to go forward with that heat illness rule. There's been a workplace violence rulemaking ongoing for several years as well. We think it's likely that the Trump administration will put a halt to that and not issue a new rule. There has been new workplace violence regulations that apply more generally in California, and the experience of the regulated community has been it's very onerous to comply with those and to develop programs and to track workplace violence specifically on a separate log and things of that nature. So I would think that would be motivating to the new administration. Another hot area has been the walk-around rule, or the union representative walk-around rule. And what OSHA did was clarify that non-employee union reps could be present during walkarounds with OSHA. That's subject to ongoing litigation, I believe, out of the Northern District of Texas. So it's unclear if it's going to be thrown out by the courts, but OSHA has the opportunity to withdraw that interpretation and instead say, yes, employees can have representatives during walk-around inspections, but that person has to be an employee. So we think that's likely a change that will be made as well. All right, if we go on to the next slide, please. So generally speaking, just to kind of reorient everyone, why OSHA citations matter. I think this is a big misconception among the regulated community, and we hear a lot of people say, well, it's just $20,000 or $30,000. We want to get past this incident and move on. And when we're in the Trump administration, they're still going to be issuing citations. We want to make sure we're thinking through what the ramifications are if citations are issued and how to address them. Yes, penalties is one component, but as you see in this slide, it's really only the first one, right? There's other potential issues that can come from accepting a citation. One is that it sets you up for repeat violations for the next 5 years. If a substantially similar hazard is cited down the road, typically under that same regulation, you could be looking at 5 or 10 times the penalty. And it would be a much higher classification for purposes of anyone else who views it, the company's reputation. And as we said, we think there's going to be a shift to willful enforcement and going after employers who get willful citations. Any citation you accept could be used against you as a basis for a willful. Look, you knew about this problem. You were intentionally disregarding this problem. You got this prior citation, which you accepted. Therefore, this current one is willful. So that can be a concern there. OSHA citations can be used in third-party litigation. Typically, if it's an employee who's injured, they get compensated in the workers' compensation system as an exclusive remedy. The OSHA citation, a willful citation in particular, could be used to try to get around that workers' comp system and bring it towards suit. And then OSHA citations can be very damaging to business reputation. OSHA currently has a website that lists every inspection and the outcome and citations dating back to 1972. So it's out there for everyone to see, and third-party tracking services vet those. Suppliers, business partners, they may be getting updates in their due diligence on your OSHA record. So having a serious on your record or having some sort of higher classification could be very damaging. And finally, one thing we saw with Biden administration was a lot of press releases. That was the theory from Dr. David Michaels back in the Obama administration, that a press release can do as good as 100 citations because it really scares the industry into compliance. That hasn't been the philosophy as much in the first Trump administration. They weren't issuing the press releases, but we think they're likely going to be back. They were back with Biden, and they're not going to be back in the same amount of force with the second Trump administration. And then finally, criminal liability, right? Any citation that results in a fatality could potentially result in criminal liability to the employer. And that's to management, to safety management, to operations management, who had some role in protecting the employee. And that's if there's a willful that's issued as well. Go on to the next slide, please. And we'll skip this one and go to the next slide and back to Melissa.
Thank you, Adam. So when OSHA comes knocking, there are a number of things to keep in mind, whether that be under a Trump administration or a Biden administration. And I'll get more into those in just a second. But first, your communications with OSHA are of the utmost importance. Anything you or your employees say or do can and will be held against the company. So when communicating with OSHA, it's very important to, one, just be truthful. You have the right to take OSHA's questions literally, and our recommendation is always to keep your responses simple and short, and to not volunteer any information that does not answer a direct question. If you don't understand a question, don't guess, don't speculate, or volunteer any information that wasn't requested. You have the right to ask for clarification, and if you don't know the answer, a perfectly okay answer is to simply say, I'm not sure, let me check on that and I'll get back to you. Again, you want to avoid any speculation. Anything you or your employees say will be taken as fact and can be the basis for a citation or for employer knowledge. For example, your comments, whether in passing, just chit-chatting with the compliance officer while they're on site, or in response to a direct question, it's eventually going to make its way into OSHA's inspection file. And just some quick good practices for OSHA inspection management. It's always good to have a written process for your on-site management to review when OSHA does show up. This would include a rundown of the process, who to contact, management expectations, and company and employee rights. If you need a template, please feel free to reach out. We'd be happy to share one with you. When OSHA does show up, company management should always be professional, attentive, and cooperative, or at least appear cooperative. The proper company management contact should be called and allowed time to get to the site or call in to participate in the opening conference. Employers should always ask what the scope of the inspection is. For example, was a complaint filed, or is it in response to a reported injury? Or is it a program inspection under one of the national emphasis programs we discussed earlier? OSHA is only entitled to inspect those areas of the facility that relate to the purpose of the inspection. So depending on the scope, employers should only allow OSHA to inspect the relevant areas and or equipment. And a good practice is to plan the route to the area of the facility that is relevant. Any violation that is in plain sight is fair game and may be cited if caught by the compliance officer. Lastly, employers have the right to have an attorney. If you have questions or are not familiar with the OSHA process, a good practice will always be to seek out advice from an experienced OSHA counsel. And if there's anything that we can do to help navigate the process, you can always reach out to us. And with that, that concludes our program, and I'll be sharing the CLE code down on next slide, please. We have a new process, so you have to pull up your phone and scan the QR code. The CLE code is SS, so Seyfarth Shaw, SS 1311. And again, that is SS 1311. And we'll leave it on this slide for just a second to give everybody an opportunity to scan. But if you have any questions, please feel free to drop them here in the Q&A box. And if we can't get to them today, we'll get to them at a later time. Thank you.